Welcome to another episode of Ask the Experts. I'm your co-host, Jeffrey Walk.
And I'm Elizabeth Finlayson. We're from the networking group, TNG, which is Chicago's premier business networking group focused on helping members and making a difference in the communities we serve. Ask the Experts is an effort to share our knowledge with a wider audience.
Welcome to another episode of Ask the Experts. Today's episode, we will be discussing the value of knowing your legal rights and options so you can resolve conflict before it escalates into litigation. Our guest today is employment lawyer Lori Goldstein, who advises individuals, workers, on ways to resolve conflicts. Welcome, Lori.
Thank you, Jeffrey. Glad to be here.
Lori, thank you for joining us today. So you're an attorney that represents the individual workers to avoid dispute resolution using the courts. What drew you to dispute resolution?
Good question, Elizabeth. Good to see you. I've always been passionate about equal rights and amicable resolution so that people could have closure and move forward. That led me to becoming an employment lawyer, and I spend a lot of my time trying to negotiate peaceful resolutions so that clients can avoid court litigation.
So I think it's interesting when you talk about peaceful resolution. I think when people think about courts, conflicts, employment issues, I think that's not what they're thinking. Are there different types of resolution that are available?
Yes, there are. If the parties, the employer and the employee, can't resolve themselves, and sometimes you can resolve with your boss or with HR, I would say the next simplest step is to retain an attorney who has the expertise and objectivity to discuss their concerns, try to find a compromise resolution without emotions, and reach some kind of settlement. If that doesn't work, there's mediation as an option, where each side basically presents their case to a mediator, and the mediator decides the case. Sometimes if an employee, for example, files a discrimination or harassment claim at the Equal Opportunity Commission or Illinois Department of Human Rights, where those claims are brought, sometimes there is mediation provided by the agency. So the EEOC provides a free mediator, and if both parties agree to mediate, they can often resolve right there. But mediation is not binding. So the third option would be arbitration, which is kind of like mediation. It's between mediation and a full-blown trial, but that would be binding. It's you bring your case to an arbitrator, there's exchange of information, there's arguments, there's witnesses, and then the arbitrator decides the case and it's binding. So another option is if an employer has employment practices liability insurance, EPLI, that covers these kinds of claims. So they should talk to their insurer, and if there is coverage, sometimes as insurance goes, the insurer wants to settle it early, possibly for not a lot of money, and just avoid the risk of litigation. So sometimes that's out of the company's control.
So Lori, there's a lot of different ways to avoid going into court, but there are times when the disputes just don't seem to get settled, or if it's not binding, well, they wind up back there. When does that typically happen? What are the patterns that you're seeing?
I would say, there's a lot of emotion that's involved in employment in the workplace. It's not the same as at home, but you spend a lot of your time at the workplace or in the work environment. And I've seen a separation or a termination of employment be a lot like a divorce for some people. So sometimes one or both parties are just so stubborn, or there's so much emotion, they can't see past the trees and resolve it. And then it's a good idea to, if you can't resolve it through any of these other means, get a judge involved. Often a judge will try to settle the case early, get both sides in with their lawyers, really talk honestly and practically with them. That sometimes will settle. And sometimes a case won't settle until, you're ready to go to trial and you're on the courthouse steps, basically. And usually it's the employer that says, okay, we don't want to take the risk of a jury trial. Here's what we'll offer. So I had a case that was in court for 4 years in federal court. We went through multiple depositions and exchange of information, and the company filed a motion to dismiss it, which the judge denied. And the judge found that we had very strong claims. And because of that, at the time we were about to schedule trial, the employer said, okay, we'll settle. And they gave us a good offer and it settled. So, but it took 4 years.
A lot of times people, they watch TV, they think, hey, I'm unhappy. They tend to jump into court before they've really thought about even resolution. I mean, are there times, a lot of people that don't even realize that you can resolve it out of court and that there are multiple paths?
That's correct. If somebody has a good attorney who explains the benefits of first trying to resolve without litigation, somebody who gives them honest and practical advice, that person hopefully wouldn't jump into litigation. Sometimes it means explaining to somebody that their situation is or was unfair, but not illegal. And there are no legal claims. So you can be mad and angry and it was possibly unhealthy, etc. But you really have to move forward, and there's your closure, and if they listen, they move forward. But sometimes I've seen the opposite. Somebody comes to me and said, this is what happened. And it took, over 10 months. And I never complained because I was afraid if I complained, I'd get fired. Even though there's a whole policy that says you need to do this and you need to complain to this person, or they just up and quit. Things got so bad, I couldn't stand it anymore. I walked out. Now what? And it's like, you shouldn't have called me first. Don't just quit, because there are ways to resolve it with an employer where they might be happy that you're approaching them and saying, listen, I know it's not working out. Neither of us is happy, but can we do this together and figure out a way to transition? Give me some money, some severance, some time where I'm on a paid leave of absence and I can look for a job. So there are ways to resolve it. So, talk to somebody first.
That's a good idea. So why isn't resolution pursued more often? We don't hear about resolution as much as we hear about trials.
Well, it could be because of the media, and all of the TV shows and movies about law, but the majority of these employment disputes are never litigated, or most of them are settled. People just hear about the juicy ones, or the allegations of Me Too and all of the stuff that's out there, but they don't hear how they get quietly settled. Again, sometimes people are stubborn or very principled and they feel strongly about their position and they don't want to resolve. They want a judge or a jury to decide. Sometimes it's an attorney who's hard-headed or stubborn, or sometimes wants to keep the case and doesn't want it to settle. So they encourage their clients to keep going. But it's said that a good settlement is one in which neither side is happy, because both have to compromise and sacrifice. And so when a client hears that, it makes them feel a little better. You can't get everything.
Right. I think that's good advice. And I think it's also important that people understand more about that there are other options, and not everything has to go the full 9 yards.
Exactly.
This is really interesting, Lori. So one of the things I'm hearing in here, and I think this is true of conflict in general, is that people have a need to talk. And a lot of the process or the way you move people forward is you're getting them into the room to talk in a constructive way, which probably wasn't happening before. Either there wasn't talking or it wasn't constructive. But then I was wondering, when you gave the example of when things go into court, I wonder if there are times when it wouldn't make sense to settle, where maybe settling is best for the individual, but maybe you are trying to change the workplace or change something for other people. Are there times that you think that a person should go the other direction so that the workplace changes more?
There are a lot of people who feel strongly that they want to make change and they're uncomfortable, if they're comfortable enough bringing a claim, sometimes they're uncomfortable just, taking the money and running and not making change. Sometimes you can do both though. You can, make the company aware and get them involved in resolving the dispute or the litigation and see, how one case could really damage a company and the morale, et cetera. And maybe that would make change. And even when there are settlements, there are a lot of exclusions and exceptions to confidential settlements and to what a person can or cannot say. You can settle a case and get paid a lot of money. You're still allowed to file a charge at the EEOC or the state agency. You wouldn't be able to collect any money out of that case, but you can put that case out there. So now it's public and the company has to defend it and say, why did it do why did it, take these actions? And you can talk to other employees and maybe get them to make change. But you're right, sometimes there are principles on the employee side too, and that's okay. I mean, if somebody's willing to go through it, I don't discourage, I discourage, but I don't say don't do it. I have them talk to litigators.
Interesting. So given the increasing backlog of work for the courts, does it make sense, intellectually and dollars and cents, for both parties to pursue conflict resolution?
I would say, economically, almost always it makes sense because it's costly to do litigation, especially for an employer, because the employer has to pay the employer's attorney's fees and costs of the defense, even if they win. And if they lose the case, they often have to pay the employee's fees and costs as well. That's under some of the employment laws. So that's economic reason. Another reason is, you want closure. It would be a delay in closure of the case. A company has to have, spend time, money, have their employees that are witnesses be involved in depositions, a trial. There's the public relations aspect of a company being in litigation. The same thing for an employee, though. Sometimes you don't want to burn bridges with an employer or in the industry or have a reputation of filing claims against your employers. So to me, I think there's so many more reasons to resolve without the public litigation.
So are there steps that workers should consider using proactive consultation with attorneys like yourself to avoid the disputes or conflicts?
Yes, I would agree with that. I think I first would encourage employees, again, to talk to their managers or HR or somebody at the top if they can, and let them know what's going on and try to get it resolved. If not, or if they don't feel comfortable, then, if there's leverage there, legal claims or things that are, that seem to me would provide a basis for a good settlement. I write a demand letter, is what I call it. I write a story about the client, the relevant history at work, the things that happened that we feel were illegal, and a proposal for resolving it. So it's all in there and we hand it to the company, and almost always we get a resolution that way. If it doesn't resolve, some of the employees just walk away and move on, and others may decide to file claims.
It's been an interesting last 12 to 14 months and rolling with COVID. It's not going to go away anytime soon. And there's been a lot of mixed messages around what you should do, shouldn't do, protect your employees or whatever, follow the state guidelines, federal guidelines, follow your own guidelines. How have these complicated matters between employees and employers?
You just said it in a nutshell. That's been a big part of it. Are, obviously the changes that we were not expecting, changes in the workplace, changes in the world, and then these laws that have been changing, regulations, the interpretations, the analysis. So it's been a whirlwind. There's been a lot of mixed messages. And so on both sides, there's the shutdowns and the stay-at-home orders. That creates issues around whether employees can work from home, whether they should be furloughed, which is basically a leave of absence, whether that should be paid or unpaid, or should they be laid off and get unemployment. Then there's some employees who have the general fear of going to work, even if it's completely safe and the company's done everything they need to do. It's understandable. But now we're going on a year and you can't stay out of the workplace or expect a company to hold your job open that long. So that's been an issue. There's all the health and safety regulations, and those bring into play disability rights and age discrimination. Some employers feeling paternalistic and meaning well. The employees over age 65 just don't come to work. We'll put you on a leave of absence, and when things get better, you can come back. Well, there are people 65 and older who are completely healthy and fine going to work and have no reason not to. So an employer can't speculate and just try to be nice and protective. On the other side, if an employee has disability issues or reasons they need accommodations at work, then companies have to deal with that, discuss that, try to make accommodations. And there's been a lot of back and forth. Each time there's restrictions either increased or decreased, then there's another question of, what do we do now? Do we phase in this many people, or how do we change the workplace? Kind of like they're doing with the schools.
One of the things that's interesting is in institutions, it seems like it's a little bit easier to mandate anybody coming in needs to be masked and protected. But small shops, restaurants, other places, a lot of folks don't feel compelled or supported in telling customers, you got to come in and mask.
Right.
And we've
Right.
seen conflict arise around that whole area.
Right. And that endangers the employees, the customers, everybody. And it's not a good situation. And there are rules and then there are guidelines. And some of the businesses decide that since they're guidelines that aren't enforceable law, they don't have to enforce them, or they can be a little bit flexible, but it doesn't make things easier for everybody else.
Right. I mean, it's a gray area, and I think unfortunately it's going to be a rich tap for a while.
Exactly. Yeah, it'll change the way we do things and the way we think from here on out.
Yeah, it's interesting. I've seen, I think, 2 nonprofits at this point where there was a conflict with an employee who didn't want to come back to work or didn't want to come and perform certain duties because of COVID. And yet it also seemed there was already an underlying issue between the employer and the employee. So I could imagine for your work that just adds that extra layer and dimension you're trying to tease out in these resolutions. So switching topics a little bit here, we've talked about COVID and impact of work environments, but technology is also something that's reaching into companies in a lot of directions nowadays and allowing us to have this conversation, but there aren't boundaries either. So what guidance should workers consider when using a new technology at work?
That's a great question. That's a great topic, and it's very timely because many of these companies are now working either all remotely or hybrid, and they have to be using technology. We use it so much, personal lives and professional lives. They're using it for court proceedings, virtual webinars. And I know that in the past year, a lot of people have been hired to new jobs where the whole process of recruitment, interviews, and hire, and even starting the job have all been remote. They haven't even been at the work site yet. So employees need to know that generally employers can monitor and see what you're doing on their equipment, on work time. There's really no expectation of privacy. Employees need to behave, keep it professional. Don't send emails and texts and things that you wouldn't want your employer to see. Employers can also take action against employees for social media activity on their own equipment, outside work time, at home. There are restrictions on what employers can restrict, but they can take action if employees post false or defamatory or malicious comments, if they're disparaging that's unrelated to work, it's purely personal, or if they're communicating to third parties and disparaging the company's products or business or reputation and trying to damage them. So employees need to be careful what you're doing at home on social media. And even sexual harassment and other types of discrimination and harassment can still occur in a remote environment, which is what I teach when I teach sexual harassment training. But employees and contractors now, both covered by the Illinois Human Rights Act and protected against sexual harassment. Companies and employees need to know that when you're working from home and you're working on these systems, you have to continue to behave. A third thing about technology is that if employees are required to work from home, required by the employer to work from home because either there's no office or the office is closed, in Illinois, employers have to reimburse employees for the expenses for working from home. So related internet and phone charge and computer and things like that. So that is something that has been an awakening for many.
So one of the things that I often see with technology is that even if it's your own equipment, hardware, laptops, whatever, the employer will still want to monitor what you do. And so they may ask you may have a disclaimer of different rights that you waive. Now, not everybody's going to call Lori and say, gee, should I sign this, Lori? They're just going to do it, right?
Right.
And so that may open the door for other kinds of problems, perhaps.
Well, if people use their own equipment only for personal reasons and not for work, then an employer obviously has no right to that. But how many people do? We either use it, we usually mix the uses. And there's been many occasions where somebody is, let go or quits and they want the backups and your phone and your everything. They send it to an expert, a forensic expert, to make sure there's nothing on there that you shouldn't have confidentiality wise. And sometimes they find things that, you really don't want them to find.
Right. So one of the things that is a challenge is just your own privacy, because if they take your hard drive, well, they can see everything that you've been doing. And it doesn't, they have access to everything. So there needs to be a line of demarcation there.
Well, in the situations I've had, goes to a computer professionals, they do the forensics examination and they make a list without saying what's the content of what are these emails, what are all the different things, and they give the employee's attorney the right to go through it. And I've spent hours doing that so that we say this stuff does not go to the company and the rest of they get. And then the company's attorney makes sure that we're telling the truth, so you have to get, but it's expensive for both sides.
Right. And the other part of that is that if the employer says, just give it to our IT department, we'll go through it.
Oh, yeah.
What's the guidance there?
I would say, I wouldn't give it up. If it's company equipment, then
That's
you
different.
have an issue. But if it's
Right.
your own equipment, then you fight it. If it's, mixed use,
Mhm.
you don't keep it, but you have to find a way to have a third party get involved.
Right. Lots of interesting turns and twists there.
Yes, yes.
Well, we could talk for hours, Lori, but the information you've provided is great. It's been wonderful talking to you. If folks want to get in touch with you, and how do they reach you?
A couple of ways. They can call me at 847-624-6640. My email address is lori.a.goldstein@gmail.com. And my website is lori.goldsteinlaw.com. This was a very interesting conversation. It's fun to answer questions and have conversation as opposed to presenting and just giving a speech. So I enjoy this.
Me too. I learned a lot. I did not know all those pieces about technology. So I'm so glad you shared that with me. Thank you for your time today. The information and guidance was really helpful. I know it was for us, and hopefully anybody listening. We greatly appreciate your expertise and know that our listeners will find it equally useful.
Thank
Thanks,
you so
Lori.
much. Thank you. I appreciate the opportunity.
Thanks for watching this week's episode of Ask the Experts.
I'm your co-host, Jeffrey Walk.
And I'm Elizabeth Finlayson.
Don't forget to send us your questions, suggestions, or ideas. As always, you can reach us at asktheexperts@gmail.com.
Have a productive week.